LaDona here with you on News Radio 600 KOGO on iHeartRadio at KOGO.com. And Prop 46, we're going to see this. We have to talk about him, even though, most of the time our eyes start rolling back in our head. We're like, no more props. But we have to do it because, yes and no can mean the difference between costing you a lot of money or potentially saving you a lot of money. Some props are really good. Some of them are really bad. Now, according to the UT San Diego editorial board, and they just released this on their look at Prop 46 on September 22nd, they say after more than a century of experience with direct democracy, Californians who pay attention to the process are attuned to how special interests try to use it to dupe voters for their own gain. They say that's why we're confident they'll see through the pathetic scam that is Prop 46. Now, it's a ballot measure, and apparently there is a certain amount of frustration that there is a cap on pain and suffering in medical malpractice lawsuits. It's a cap of $250,000. There's no limit, by the way, on how much a malpractice victim can get for direct financial losses. So the cost of medical treatment, rehab, the loss of income, things like that. There is no cap and never has been one on that. But it's $250,000 for pain and suffering. And that seems to be the main brunt of Prop 46, is to make that cap go higher. There is a pretty good case to be made. This was a state law from 1975 that the cap is on the low side. Absolutely. However, the way that Prop 46 operates, this could actually end up not keeping your medical costs down as well. And this is the concern about those who are against Prop 46. And another part of this is apparently there is, and this is the strangest thing, because I have had two primary care doctors, or actually three, since I've lived in San Diego. And none of them ever smelled like booze. None of them were ever intoxicated that I could tell whenever I saw them. Granted, I was sick when I saw them sometimes, so maybe my perception wasn't so good. But there's a drug testing provision in this as well. Apparently, there's rampant substance abuse among doctors. Now, think about your doctor. Because most doctors are going to be, primary care physicians. Okay. You've got plastic surgeons, you have specialists, things like that. But think about your primary care physician. Do you think that your primary care physician is on drugs? Is intoxicated? Is struggling with abuse? If you've seen a doctor for a long time, don't you get a pretty good clue into their personality? And granted, anybody can hide addiction. That's not really that hard. But is it such a problem that we need to mandate random drug testing of all physicians who have hospital privileges? Oh, do we also need to create a database to increase tracking of addictive prescription drugs? This is the part that worries me, because, we have these conversations about painkillers. And I say this as I do not have a dog in this hunt. I do not take painkillers. I can't take them. I have a paradoxical response to them. I might as well be eating pure meth. It's absolutely horrible. I have no desire to take a painkiller for any circumstances at all. And I won't. It turns out that there's only one way that I can take them, and I won't really go into that. But they're just, that's not a drug that I don't enjoy it. Most people I know who have taken them don't really enjoy them that much. They make you too logy. Okay, yeah, I want to walk around in a coma all the time. That's always fun. So this database would increase the tracking of addictive prescription drugs. Okay, doesn't seem like a bad idea right off the bat, but what is an addictive prescription drug? Let's say that you have an anxiety disorder. Does your anxiety disorder have your doctor giving you a drug that's a benzodiazepine? Well, guess what? That's addictive. There are a lot of ways, and if you have somebody who has permanent injury, permanent nerve damage, permanent anything, tracking these kinds of drugs would make you look like a drug addict when you're just a person who's in pain. And that to me can be very scary. We're demonizing a group of drugs because people are drug addicts. Well, I can't help anybody else being a drug addict. That's up to them. That's their decision. But that doesn't mean that we need to make it harder for other people to get drugs that they might need. That's what concerns me. Dr. Ted Mazur is joining us, a speaker for the House of Delegates for the California Medical Association. Hi there, Doc.
How you doing, LaDona? Thanks for having me.
Well, good to talk to you. First of all, is there rampant drug addiction in doctors? Is there a problem?
Is there rampant drug addiction? No. In a simple answer, no.
Okay.
Are there problems? Yeah, we understand. We're a profession, a high-stress profession, as any group of people who are working. There's going to be some problems, and we are, as a profession, always looking for ways to make things safer and to identify where there are problems and to deal with the problems effectively, rapidly, and to maximize patient safety. So, yes, there are always problems, but no, it's not a rampant problem. The figures that have been tossed about are done to scare people, and they are certainly not representative of what's going on.
Let's talk about Prop 46 very specifically. Apparently, there's a certain amount of frustration by trial lawyers over this 1975 law that put a cap of $250,000 on damages for pain and suffering when it comes to medical malpractice lawsuits. But there isn't a limit on how much a malpractice victim can get for direct financial losses.
No, there are no such limits. And in fact, while the trial attorneys are trying to say that we need to somehow inflate this retroactive for the non-economic damages back to 1975, the reality is that in the malpractice awards, when somebody prevails in a malpractice case against a physician, those awards have gone up 250% relative to inflation. They've outpaced inflation. There is no need for an inflationary index to something that is not an inflationary number to begin with, and that's why it wasn't pegged to inflation back in 1975. It was a number derived to make sure that people had access to care, and it's worked.
Now, what exactly, who put together Prop 46? Because according to the UT editorial board, they say that this is all trial lawyers, but there is a group, and one of them is going to join us here in just a few moments as well, after we get done with you, Dr. Mazur, Jamie Court from Consumer Watchdog, who's a part of the Yes on 46 bunch.
Right. Jamie Court with Consumer Watchdog is Yes on 46, and in many ways we would consider Consumer Watchdog as a mouthpiece for trial attorneys. Jamie Court has been after an increase in this cap for many years, as have the trial attorneys. And we're talking about the med-mal trial attorneys, not all trial attorneys are part of this. And the legislature has wisely seen that this is a system that works well for patients. It works well to maintain access to care. It's obviously not what the trial attorneys want, because they want the ability to sue more frequently and to be able to recoup more of the settlement by having higher awards. That's the problem. That costs all of us money.
Well, and that brings me to this. The Nonpartisan Legislative Analyst's Office said that Prop 46 could increase healthcare costs borne by local and state governments by hundreds of millions of dollars a year. The cost to individuals who buy their own health insurance and to businesses who provide coverage to their workers would likely be in the billions. So that means that health insurance costs are going to go up.
Nothing is free. And the average family of four, by independent analysis, would cost about $1,000 more per year just to maintain the current coverage. All of this in an environment where we're trying to improve access to care and decrease costs. Bad timing, bad proposition, and totally misrepresentative of what's going on.
Now, going back to a little bit of the language, what's the worst part of the language in Prop 46 that you can find? I realize that this doctor drug testing kind of comes out of nowhere. I don't know what that has to do with the limits on financial losses. Is there some sort of correlation between doctor drug addicts and medical malpractice suits?
No, in fact, that's a great question, LaDona, because no, there is absolutely no correlation. Nobody's done any work on that. And you can ask Jamie Court this when you speak with him next. He was quoted in the LA Times by Michael Hiltzik early on in this, basically saying that the drug thing had nothing to do with their original intent, which was the rise in the malpractice payout cap. But it was the one thing that pulled so well with focus groups that they put it in as the ultimate sweetener. Translate that in to deceive the public into voting for something. That's not about patient safety. We can talk about drug testing of physicians and when it would be appropriate, but the way this was written and the way it is worded in the ballot is deceptive. This is not about a good form of drug testing doctors to make sure the public is safe. This is about raising the cap on malpractice awards. Everything else is a smokescreen. Are there issues? Yes. Do we have some remedies? Yes. Could we do better on watching for doctors who may be under the influence? Yes, and we did in the past. We had a diversion program to help draw those doctors out and get them better. That program, unfortunately, got defunded, much like the Cures database, which is the third part of this, the drug database. That got defunded by the state as well. We can talk about, should we use a database? Physicians are not opposed to it. We want to use it in an appropriate fashion when it works, and the current system does not work and will not be ready to work. We have essentially taxed ourselves with the legislature, raising our license fees to develop a database that will work and will be secure and will be good for patient safety. Not something on a ballot prop that just got thrown down to, again, distract the voter from what this is really all about.
Dr. Ted Mazur is with us here on News Radio 600 KOGO. He is the Speaker for the House of Delegates for the California Medical Association. I have to take a quick check on traffic, but I want to ask you about medical malpractice insurance because that's been a major problem for doctors, I think, in the state of California for quite some time. And I want to know what Prop 46 will do to those medical malpractice insurance rates, thus driving up the cost, obviously, of medical care if those go up on you. But first, really quickly, Mark Zegan with traffic.
Good afternoon, LaDona. From the SDCCU.com Traffic Center, the freeways are moving along well, but we still have ramp closures in the East County. Due to some police activity, the Grossmont Center ramp to the East 8 remains shut down, as does the eastbound 8 exit to Severin. I'm Mark Zegan, your next KOGO traffic update just ahead at 1:26.
Okay, medical malpractice insurance. And doctor, I have to apologize. I don't know what sort of doctor you are.
I'm an ear, nose, and throat surgeon.
Oh, okay. So some of my very favorite people are ear, nose, and throat guys. So tell me about, medical malpractice insurance, because that's a very large part of your cost as a doctor, is it not?
Sure it is, and in fact, we can talk about how fees are developed for physician services by Medicare. Malpractice costs play a role in how fee structures are developed, which means if malpractice costs go up, that means fees that are reimbursed to physicians by payers, by Medicare, by Blue Cross, have to match that. They need to go up. It's an actuarial figure. It's not arbitrary. And the reality is, if you're going to have higher awards and more frivolous lawsuits, because it's more attractive to file a lawsuit if we raise those caps fourfold over what they are today, that will cause rises in malpractice insurance rates, regardless of the allegation that Prop 103 will stop that. Not true. It goes up in reality because it costs more, and that somehow gets passed back down to the purchaser of insurance, the employer or the individual, or we can even look at the exchanges, the subsidies, the cost there, everything has to go up because you're putting an artificial inflator in going back to 1975. It does not make sense. And I can tell you the impact on access to care. I had a discussion with a neurosurgeon here in the East County, San Diego area last week. Some of these procedural specialists are looking at increases of probably 2 to 4-fold on their malpractice premium. This is an environment where San Diego is not well reimbursed for physicians. I mean, physicians make a living, don't get me wrong,
right,
but they're not highly reimbursed in San Diego. This is a long-standing member of our community doing neurosurgery and covering emergency rooms, and he said if his premium went up that much, he's gone, he's done, he's out of practice. We want to protect patient access to care, control costs, and yes, do things that are safe for patients. We absolutely understand where there's a problem, we need to address it, and we have done things. We will continue to do things. Had the trial attorneys come to us and talk reasonably about where we could do drug testing and put it through the legislature, maybe we would have come up with something that's perfectly appropriate, not random and overbearing. I mean, it is kind of ridiculous to tell me when somebody finds an adverse event occurs on a patient I might have had something to do with a week ago, that I have to run in and pee in a cup in 12 hours or my license is suspended and I'm guilty of negligence, even though I haven't touched that patient in a week. It just happens to be today you discovered something, and I may or may not have been any part of that, but I got to go pee in the cup, or I open the door for another lawsuit because there's assumed negligence by the trial attorney.
Boy, I'm very, very concerned when we talk about cost of medical care going up, especially with Obamacare. We have increased access to doctors. We have had a shortage of doctors, and it's not really, if I was a kid going to school, honestly, I would take a look at physician training and go, well, no, because for how much money you have to lay out to become a doctor, what you're going to be getting back is not as good, and the risk that you take in being a doctor, I think, with malpractice cases is very, very high.
It's part of the profession. It's something we accept, but we don't want it to become so onerous that people shy away from coming to California to practice medicine or retire early from their practices because of some kind of a draconian change that was really to suit a small group of people to have the access to sue more often and for higher rewards. That's why we've got this broad coalition of people on all sides of the aisle, in business, in unions, backing the no on 46. The number of organizations, the breadth of the organizations that are opposing this shows the public that everybody who stops to think about this, other than the trial attorneys, recognizes this is not good law if this were to pass. This is not the right time to be putting these things on the table. But if we're going to talk about them, let's sit the stakeholders down and come down to a reasonable way of dealing with these issues. Not something on the ballot written in a deceptive fashion, given a title that has nothing to do with its ultimate aim, and grouping three things together that, yeah, I know they're saying it's all under patient safety. They're not. There's two smoke screens and the reality is more lawsuits.
All right, well, we're going to hear from Jamie Court coming up in just a few moments from Consumer Watchdog, part of the Yes on 46 bunch, and ask Jamie what they think of the arguments that you've brought forth, Dr. Mazur, and I appreciate the time.
Thank you very much. Glad to have the opportunity.
All right. So Prop 46, yes or no? The UT says no, but somebody brought up something that I think is really interesting. It says, my disabled sister who was killed by medical negligence had no income, no job, no spouse, no kids. Her case only qualifies for the non-economic damages that are capped by MICRA. So we'll ask Jamie Court about that coming up next here on News Radio 600 KOGO. Oh, my gosh. You know what? I was going to break there because I have brain damage. MCAS Miramar Air Show is coming up. I don't know why I didn't pay attention to what you were telling me to do, Rick, but I didn't. So sorry about that. The Miramar Air Show is coming up this weekend, this Friday through Sunday. Take the whole family. You can experience breathtaking stunts. The Blue Angels, always so much fun to watch. The best civilian pilots at one of the world's best air shows. Parking and admission are free. And so that means everybody gets to go. But I still have your opportunity to win a pair of box seats to Saturday's air show. Box seats. So you get to sit instead of stand. It's awesome. Listen for your chance to win a pair of box seats to Saturday's air show. Plus, you can listen for all of our fly-by-fly coverage that's live from the flight line noon to 4 p.m. this Saturday right here on News Radio 600 KOGO. I will be giving away those tickets within 40 minutes from now, 40. So 40 minutes from now, you will get a chance, within 40 minutes, I should say, you'll get a chance to get those Miramar Air Show tickets. So give us an email at LaDona@KOGO.com, LaDona@KOGO.com. And is it about patient safety? Is Prop 46 about patient safety, or is it a scam? The answer could be somewhere in between, and we'll find out next. Jamie Court is joining us from Consumer Watchdog. They are backing 46, Prop 46, which is going to be on the ballot in November. Is this about trial lawyers and a scam to get more money, or is this about trying to make sure that people who are harmed by medical malpractice get the help that they need and deserve? So we'll ask about that next on News Radio 600 KOGO.
Spy drones probably ought to be limited, right? So why is our governor vetoing a law that would protect your privacy? It's tomorrow morning with me, Chris Merrill, on News Radio 600 KOGO.
So we heard one side. Dr. Ted Mazur joined us, the Speaker for the House of Delegates for the California Medical Association, and he is a part of the coalition of people behind No on 46. Prop 46 is going to be on the ballot in November, and it affords you the opportunity to have a couple of different things happen. There was a 1975 state law that put a cap of $250,000 on damages for pain and suffering in medical malpractice lawsuits. Now, keep in mind, there's no limit on how much a malpractice victim can get for direct losses, the cost of medical treatment, rehabilitation, the loss of income. But pain and damages, that cap is at $250,000. And since it was in 1975, you know what? There's a pretty good argument to be made that that's a number that should actually be a little bit higher. However, this particular prop also does a couple of other things. It would scrap the $250,000 pain and suffering cap, and it would also cause random drug tests for doctors. How much would this potentially increase the cost of medical care? That's one of the things that you have to look at. And what Dr. Mazur just said is that medical malpractice insurance costs do play a role in fee structure in a doctor's office. So let's find out if it's going to be as bad as Dr. Mazur said by talking with Jamie Court, who is with Consumer Watchdog. Hi, Jamie.
Hey, how are you?
Doing good. So tell me why, or what is the real impetus behind Prop 46? Because it sort of goes at this from three different ways, and they seem to be unrelated.
Well, they're not. They're very related. And if you believe the malpractice insurers who have spent 75% of the money against this campaign, $45 million, that's true. They don't want to pay out for doctors who are impaired and hurt people. They don't want to pay out for doctors who are negligent. And today, if you are a victim of one of those doctors, you can't get access to the court. And this initiative is all about deterring and detecting dangerous medicine, and it's all about getting victims justice. And today in the Capitol, in fact, like right now in the Capitol, there's a legislative hearing on Prop 45, and a doctor, Dr. Gary Heller of Chico, is testifying. He lost his wife, Linda, to a doctor who'd been convicted of 3 DUIs for alcohol and prescription drug abuse. And he didn't know it because the doctor wasn't detected, and doctor was still practicing. Medical board never took his license, and after she died, because she was a homemaker, she basically he didn't have access to the court. Because what happens is, if you have a homemaker or a child or a senior who dies from medical negligence, the maximum you can recover is $250,000. They don't have wage loss, and they don't have dependents, and they don't have medical bills. And that is not enough to get a case going in the state, because the medical malpractice insurance companies, when you're bringing one of these cases, defend it vigorously. And literally, people have to spend $100,000, $110,000 in costs to bring this case. And attorneys' contingency fees have to come out of that $250,000 in addition to those costs. And an attorney's thinking, why am I going to bring this case today if there's maybe $40,000 or $50,000 left for the victim if I succeed? And that's because 38 years ago, Jerry Brown set this cap, and it hasn't been indexed for inflation. So the initiative is very coherent. It's about saving lives. It's about detecting doctors, just like we do with pilots and other safety-sensitive positions, if they are high or drunk on the job, or if there's an adverse event they're involved in. It's about forcing doctors to check a database before prescribing narcotics for the first time to a patient, only the first time. And it's also about making sure that if a victim of medical negligence is indeed a victim, they should have a chance to get access to justice, not only because it's important for the family to have some kind of compensation, but even more importantly, it's important for society to know through legal deterrence who these doctors are, so we can get them out of the system. And it's all very common sense. When you put a ballot measure like this on the ballot, it's a pretty expensive thing. It costs about $1.8 million to collect the signatures, and we wanted to do as much in this ballot measure as we possibly could.
Now, what about the medical malpractice lawsuit? Medical malpractice insurance costs. I mean, it seems pretty obvious that if the pain and suffering cap goes from $250,000 to $1.1 million, if you're a doctor, your medical malpractice insurance is going to go up commensurate with that.
Well, medical malpractice insurance rates are really tightly regulated in the state under a law called Prop 103, passed 27 years ago. And malpractice insurers have to prove they need a rate hike. I don't think they can do that unless a lot more claims are paid, because right now malpractice insurers are paying out 20, 30 cents of every premium dollar they take in. Very low. If they start paying out 80 cents of every premium dollar they take in, they can go back to the insurance commissioner and get a rate hike. But the reason malpractice insurers are literally they have spent $45 million against Prop 46 is because they don't want to pay out legitimate claims, and there is plenty of room. We have half the states in America that don't have a cap on damages, including New York, a cosmopolitan state, no cap. And all we're suggesting here is an index for inflation, not removing the cap, not getting rid of other restrictions in the law that came in 1978. There's a limit already on attorney's fees in this, and we didn't touch that. There's already a limit for mandatory arbitration. There's a lot of things in the law that still work toward the benefit of malpractice insurers and the doctors. All we're saying is if a child dies, if a senior dies, if a homemaker dies, their family shouldn't be limited to $250,000, a law that the legislature set in 1978. It should be indexed for inflation. Even the author of that law, Barry Keene, in 1978, said he thinks the initiative should be indexed for inflation. And by the way, he said in the Santa Rosa Press Democrat, yesterday in the paper that he would vote for Prop 46 if he was in California, and he is the guy who authored this law.
Jamie Court is with us. Jamie is with Consumer Watchdog, and he is fighting for Prop 46. We heard from Dr. Ted Mazur prior to hearing from Jamie on what he believes are the negatives of Prop 46. Now we're hearing about the positives of Prop 46. What about this database to increase tracking addictive prescription drugs? I always get concerned, and mainly that's because I know that there are people who do need those drugs, and while we like to demonize them, I mean, who wants to be hooked on Vicodin, there are people who are in a significant amount of pain that should be able to get pain relief. And what if they can't, if we start demonizing too much the drugs that actually relieve that pain?
No, I'm 100% agree with you, but this initiative basically takes an existing database called the Cures database that was developed actually by the proponent of the initiative after he lost his children to an addict who was overprescribed thousands of pills. It's existing. So every time you have a prescription, it's dispensed by a pharmacy. It's in this existing database protected by the Department of Justice. We've gotten funding for that database through the legislature. What the Medical Association didn't want to do was require, as is required in other states like New York and Tennessee, that before prescribing a Schedule II narcotic, so we're talking about very serious narcotic, for the first time to a patient, they need to check that database. There is no penalty under the law for them not checking it. However, what this is saying is you want to make sure you're not prescribing narcotics to addicts. And in fact, not only is that wise from a policy point of view, but it's also wise from a fiscal point of view. And if you look at the initiative and the fiscal impact of the initiative, it says that there is a savings from the use of this database because the Medi-Cal system pays for drugs, far too many narcotics. Our whole healthcare system pays for far too many narcotics for addicts. No one who is in pain will be denied a prescription under this initiative, Prop 46. But what will happen is addicts may not be able to get their drugs, and doctors who overprescribe and prescribe to addicts will be found. And that is a serious issue because in our society we have a whole niche, and it's very true in Orange County and in northern San Diego County, where there were a series of doctors who were taken out by the DEA because they were prescribing literally 18 and 22-year-old kids, many of whom died, very, very serious narcotics. So this is a way this initiative saves money and it saves lives. And I will say this. There are ads on TV you will probably see from our opponents against Prop 46 that talk about this database, and they say there's a big threat to your privacy. It's really unbelievable because the LA Times this was just on Friday, said they're jaw-droppingly deceptive ads. The Mercury News said they're shamelessly deceptive, and they're deceptive because this database exists. It's protected under HIPAA. There is no threat to your privacy, and there is in that ad a headline that says 4.5 million people had their data breached. This isn't an ad against Prop 46. Well, that gives you the impression it's from this Cures database. You know what that data breach was from? It was from one of the hospital systems opposed to Prop 46, which is why the newspapers are beating up on the ad, because it is unbelievably deceptive. And we asked for the doctors to pull this ad down because I don't know how Dr. Mazur or the malpractice insurers, well, maybe the malpractice insurers, but not the doctors, could stand behind such a deceptive ad and then expect us to trust them.
You know what? Really quickly, though, I do want to address one thing, or have you address one thing. The Legislative Analyst's Office said that this could increase the health care costs borne by state and local governments by hundreds of millions of dollars a year. The LAO is not exactly a partisan bunch. So how do you address that?
Well, that was true from the cap, but it also said in the next sentence that there is a significant offset. It's increased state and local healthcare costs, but uncertain but potentially significant state and local government savings from the new requirements on healthcare providers, such as provisions related to prescription drug monitoring and alcohol and drug testing of physicians. These savings would offset, to some extent, the healthcare costs noted above. We have savings as well as saving lives. Yeah. Okay. Well, I look, the costs I dispute, but I agree with you that they've said that because I believe if you stop injuries, then you will stop healthcare costs to treat those injuries. It's been said by many experts that if you can limit medical malpractice, because you're deterring medical malpractice. It will save the system a lot of money.
Listen,
Now,
Jamie, I am up against a wall right here. Unfortunately, I have got to go, but it's been a real pleasure talking to you. I'm glad that we got both sides of this argument. So thank you so much for your time.
Thank you.
All right, that's Jamie Court from Consumer Watchdog, part of the Yes on 46 crowd. Well, you heard both sides. What do you think? Is this a yes or a no vote? It's going to be on the ballot, and it's up to you. KOGO.